Hi, I am Ruth Hay, founding attorney of Renaski Legal, and this is my short introduction to contracts for small businesses thinking of expanding internationally. I am a business and transactional attorney with over 15 years' experience negotiating, interpreting, and enforcing many types of contracts for individuals, small businesses, and domestic and international companies. This presentation is part of a series where we discuss certain disputes and liabilities that commercial buyers and sellers commonly overlook when entering into their business transactions. Formalities require me to mention that although I am an attorney, this presentation is only for education purposes and not to provide any legal advice. Also, this presentation forms part of Renaski's introduction series and is not a comprehensive or complete presentation on the topic. Many small businesses in the US want to sell their products and services internationally. On this slide is a summary of the topics that we will be touching on in this presentation. There are four main transactional mechanisms for US businesses planning to expand globally, and each has pluses and minuses regarding speed to market, governmental complexity, cost, integration, and political and cultural risks. The four methods are outsourcing, where you contract out services; the joint ventures, where you contract with distributors, sell franchises, or license your technology or products; where you acquire a foreign company or part of a foreign company; or where you create a wholly owned subsidiary company. Be especially mindful of what you are acquiring and from who, and have a compliance mindset right from the start. Undertake risk assessments and structure the deal to minimize risk. Tax considerations are often central to which method is selected. If a contract will result in your company doing business in a jurisdiction where it's not currently active, consider whether that would create a permanent establishment leading to an obligation to pay taxes. Therefore, it is crucial to obtain tax advice right from the start. Depending on how you've decided to proceed, then you need to think about some of the following areas. What are the most common forms of business vehicle used in the jurisdiction? And what are the main registration and reporting requirements? What local licenses will the business need? Are there restrictions on doing business within that jurisdiction? Are there any currency regulations? Are there competition laws? Are marketing agreements regulated? Are there specific statutory data protection laws? How are product liability and product safety regulated? And will you be hiring local employees or using US expats? For example, in China there are foreign ownership restrictions. You may need multiple business licenses, and there are restrictions on getting money in and out of China. This is before you need to think about the cultural differences and the contract translation costs. Take steps to protect your assets, your brand, your reputation, and your people. Strategic business relationships enable both parties to leverage their respective capital, brand awareness, market insights, and commercial positioning. If you go this route, then select a partner who is knowledgeable and well positioned in the local market, and also willing to become familiar with your strategy and practices. It is important to establish a common vision. A US company has compliance, financial and legal obligations that apply to its foreign operations. But in most countries, the US concept of compliance just doesn't exist. You will need to undertake due diligence on the people and companies you contract with to sell, distribute, and service your products. Most cases under the Foreign Corrupt Practices Act, the FCPA, involved US companies being held responsible for the conduct of third parties. Many companies starting business in a new country are pressured by a local distributor to grant exclusive rights to the territory. Granting a single company the right to market, sell, and service your products may be the fastest, easiest, and least expensive way to gain entry into a new market. But while exclusive distribution arrangements have been very good for some companies, they have also limited growth and caused some companies to fail. You may find that you can sell more products when you engage multiple distribution channels. If you are going to enter into an exclusive distribution arrangement, limit the duration of the initial contract to no more than 2 years. State that the purpose of exclusivity is to develop the entire market and is only intended for a limited time and territory. Provide tough business development goals and include termination rights if the goals are not met. Clearly provide that the exclusive relationship will only be renewed if the partner has produced results justifying a new contract and agrees to new commitments and goals. Doing business internationally requires that your company react quickly to changing situations. Face-to-face meetings are very important. Taking the time to meet and drinking those 3 cups of tea is necessary to achieving understanding and respect. That understanding and respect can get you a lot further than the best contract. Do not assume that a transaction will proceed in the same manner and speed as it would in the US. In international transactions, you might find yourself negotiating issues that you hadn't expected to encounter. For example, I repeatedly found that in negotiating with Chinese and Singapore companies, a provision that you thought you had already closed is revisited again and again, and sometimes even after the agreement has been signed. In less predictable and less stable international environments, force majeure events are more common, and what constitutes a force majeure event varies widely. Appreciate the cultural differences. Cultural norms play a significant role in the style and procedure of negotiations. Awareness of local customs indicates that you are a sophisticated and experienced business person. Be warned, however, cultural norms may have a different standard of honesty and trustworthiness from what you expect. Remain politically aware. Keep apprised of both the geopolitical situation and the internal politics of the countries in which you plan to operate. Awareness can keep you one step ahead of obstacles and help you identify opportunities. Recognize that laws and contracts in many countries are interpreted and influenced by local politics. Attempt to control the primary incentive for your foreign partner through the initial negotiation. If you are negotiating a cash deal, ensure that you control the cash until the completion of all issues. Lastly, as foreign transactions always involve significant risk, always have an exit plan in case the relationship disintegrates. It is common for international contracting parties to negotiate which language and legal system will govern the relationship, contract, and any disputes. Although the law of the US and the law of the overseas jurisdiction are both relevant, there may also be multilateral or bilateral agreements that regulate the transaction. Sometimes there are special industry-specific regulations, and if you use electronic contracts, enforcement of electronic contracts varies widely. Commonly, contracting parties from the Americas are agreeable to having New York law govern. European, Middle Eastern, or African parties are commonly agreeable to English law, and Asian parties are commonly okay with Singapore law. Business parties from different countries often write their contracts in English, but if a party is not used to English, this can cause problems, because they can later claim that they did not understand what they had agreed to. For instance, courts in China have held that a contract not written in Chinese may be void, because the Chinese party didn't understand it. Although a contract might be governed by US law, if a lawsuit is brought in a foreign jurisdiction, the local court may refuse to enforce provisions that violate the public policy of that jurisdiction. For example, if you expect to be able to enforce your contract in China, it must be in accord with Chinese law. Often US contracts disclaim liability for a warranty. US warranty law is broad. Chinese warranty law is narrow. US warranty damages are high. Chinese warranty damages are low. Under Chinese law, you cannot contract around your basic warranty obligation. Other types of contract provisions that may be void depending on the jurisdiction include termination, limitation of liability, indemnification, liquidated damages, warranty disclaimers, the charging of interest. In some countries you require a minimum contract duration, and in other countries contracts exceeding a certain number of years are invalid. The United Nations Convention on Contracts for the International Sale of Goods, or CISG, is designed to harmonize international law. It is currently adopted by 83 countries, including the USA, Canada, and China, but not the UK. The CISG only applies to international sales of goods, and it governs the formation of contracts and the rights and obligations of buyers and sellers. It does not cover many provisions found in the US statutes for the sale of goods, and it doesn't apply to contracts for services or distribution agreements. If a US company contracts with another US company for the sale of goods, the US's Uniform Commercial Code, the UCC, will apply. If both contracting companies are in contracts that have adopted the CISG will automatically apply. For example, a contract for the sale of goods between a business in Phoenix, Arizona, and one in Toronto, Canada, would be automatically subject to the CISG. However, the parties can opt out of all or part of CISG, or they can modify certain provisions of CISG if they expressly write this in their contract. If they agree to opt out of the CISG, they could agree to use US law and the UCC would apply, or they could agree to use Ontario law, or they could agree to have the law of another location apply if it is more favorable to the type of transaction. Some US companies use the CISG when dealing with legal systems that are very different from the US system, or where they may need to seek international enforcement. Incoterms are global trade rules, not laws, that facilitate global commerce. There are 11 rules which address the transportation and carrier responsibility, the transfer of risk of loss, and the import and export obligations. The Incoterm rules do not address ownership or the transfer of title. The applicable Incoterm rule must be expressly written in your contract and on all bills of lading and shipping documents, with the port or place of delivery described as precisely as possible. For example, the street address, the city, the state, and the country. Today, the two principal legal systems in the world are common law and civil law. The US, England, and other countries once part of the British Empire based their legal system on the common law system. Continental Europe, Latin America, most of Africa, and many Asian nations are part of the civil law system. Whereas the common law system traditionally has been one of judge-made law, the civil law system is composed of codified principles of law that strive to be self-explanatory and all-inclusive. Some civil law jurisdictions have much more statutory contract law that is applied to transactions. This means that a contract governed by civil law will usually be a shorter document. This difference commonly causes problems when a company from a common law country sends a traditional, lengthy and detailed contract to a company governed by civil law. Another underlying reason for the shorter contracts relates to litigation. Companies from common law countries prefer to address more contingencies in their contracts because they are faced with a greater likelihood of litigation. In civil law countries, limits on pre-trial discovery and motion practice, as well as the loser pays rule, greatly constricts a party's ability to use litigation to impose costs on the other party, so there is less need to guard against litigation in their contracts. In some foreign jurisdictions, for a contract to be valid, the parties have to go through certain formalities that add time and cost and often frustrate U.S. companies used to the relatively informal U.S. way of doing things. Some of these formalities might seem odd, but their purpose is to offer protection against fraud. For example, each party may have to prove that the person signing the contract is authorized to do so. Also, it is still common in many countries for only an original ink signature to be accepted, or for signatures to be accompanied by a corporate seal or stamp. Laws on the enforceability of electronic contracts and signatures vary widely across jurisdictions. It is important to think about enforcement early in the contract negotiation process. For example, who is likely to be suing who, how will they be served, where are the assets, and how much is at stake. In your contracts, it is important to address what happens in the event of a dispute, the law that applies in the case of the dispute, and the priority of resolution. For example, if you are using arbitrators, insert language that the arbitrators will be guided by the terms and conditions of the contract first. And if they cannot find a solution within the contract, then they should make their determination using the laws agreed by the parties. Consider whether arbitration or litigation would best serve your interests. On this slide, you can see a comparison of 5 international arbitration options: the International Centre for Dispute Resolution, the International Chamber of Commerce, the London Centre for International Arbitration, the China International Economic and Trade Commission, and the United Nations Commission on International Trade Law. With the exception of the China International Economic and Trade Commission, the rules do not vary materially, and where they do, the parties can typically contract around the differences. In international dispute resolutions, arbitration may provide greater flexibility when the law is against you. The location and selection of the arbitrator are very important steps and are commonly carefully drafted in the contract. Arbitration is not cheap or fast, and in some instances companies end up in litigation anyway, trying to enforce an arbitration judgment, or they are trying to appeal a decision made by an arbitrator who may have not had any legal training. I hope this presentation has been helpful to you, and please feel free to reach out with any questions you may have.